Sara Azari is here with us. She's the co-host of the Presumption Crime podcast. Hello to you. And, I want to ask you a similar question. Has the prosecution met the burden of proof at this particular stage?
Good to be with you, Adrian. I think that, the expectation is that somehow they met the burden of proof by way of Cohen. I think we were all looking to Cohen as the star witness. And of course, he has credibility issues. But typically, as trial lawyers, we adhere to the communication theory of recency and primacy. And so that means that we put our best witnesses first and last. I'm curious who the prosecution is going to put on last before they rest. And remember, they have a chance at redirect with Cohen. They can clean up a lot of the sort of the bruising that he sustained during this cross-examination. So, I'm holding off on opining on whether they've met their burden, because this is a case where a very skilled closing argument can very much connect the dots. And remember, we have two lawyers on this jury who can also help this jury in deliberations.
There are a lot of people who've had opinions, and we hear pundits and analysts talk all around the perception of this case. We have people on both sides of the aisle, Democrats and Republicans, saying this really doesn't have a lot of meat to it. Out of all of the indictments against President Trump, this one is the one that closely resembles a sham to a lot of folks from the outside looking in. But from a legal perspective, Michael Cohen's testimony tied with actual documentation of these records that are in question. Is there any there?
There absolutely is. I think what is different about this is that typically this is a misdemeanor under New York law, the falsification of business records. And here, the Manhattan DA is going after a felony under that code, which requires another felony to have occurred, which is the election interference. So because of this sort of layered aspect of the charges here, I think it's really easy to dismiss this, especially if you're on the other side of the aisle and on the right side of the aisle, where you say, oh, it's all a witch hunt, it's all, they're after Trump. But legally, there is absolutely a case. I think it's a lot of connecting dots. It's a lot of different witnesses and documents that need to kind of be tied in together to be able to prove that case. But again, I think Michael Cohen, I didn't see, Caitlin was referring to that pivotal phone call. Two things can be true. He could have been talking about the prank call and the hush money. So that doesn't make that call lie. And so I think that all of this is going to be cleaned up on his redirect. And then, of course, the closing argument is going to be fascinating.
Well, DA Alvin Bragg, to put this case before jurors as a felony, you mentioned, typically this would have been a misdemeanor. If this case gets tried, and let's just say that there is not the burden of proof that prosecutors are aiming for, does that mean that the case can be tried again as a misdemeanor, or does that throw the whole thing out?
No, that's a very good question, because when the judge instructs the jury, there typically is a lesser instruction, meaning that if they don't find the former president, guilty on the felony charge, they could still find him guilty of the falsifying the business, records charge, the misdemeanor. So there are going to be separate instructions with respect to the misdemeanor charge. It's not going to be a retrial. He can only be tried once. There's double jeopardy that applies. But what does that mean? I mean, that's where I think politically we're going to get a lot of backlash. Oh, you did all of this just to get him on a nothing burger misdemeanor, slap on the wrist.
Thanks for watching, everybody. Go to joinnn.com to find NewsNation on your television provider. Also, don't forget to click that red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.